We are here with Scott Gilbert. He is counsel at Watkins Eager in Jackson, Mississippi, and he is moderating a panel at this year's Qui Tam conference on February 27th and 28th of 2020. Scott, tell us a little bit about the panel, and if I'm in the audience, what I can expect to see on the panel.
Great. Well, thank you, and it's a great honor to be included, Scott. I appreciate the opportunity.
Oh, you're welcome.
So, our panel is going to address the interplay of asset forfeiture with Qui Tam actions, and there are two intersections that are of significant interest to practitioners both in the relators bar and the defense bar. The first intersection is if you are a relator or relators counsel, what does it mean for you and your ability to recover if the government seizes and then ultimately perfects a forfeiture of the same money that the government is recovering as the proceeds of the fraud? The second major intersection is for defense counsel and for defendants. What does it mean for you as a defendant and defense counsel if somewhere in the pretrial process the money that's being used to fund your defense is ultimately seized and restrained by the government in a pretrial context? And so along those lines, we're very fortunate to have three very experienced litigators in this area join us on the panel. The first is Sylvia Strikas, who's with Kellogg Hansen here in DC. She is an experienced relators counsel. One of her more prominent cases that people who are interested in the conference may know about is U.S. ex rel Westmoreland versus Amgen. She was relators counsel in that case where the government recovered right about $700 million in fraud proceeds and penalties. She clerked for former Supreme Court Justice O'Connor, and she will bring a phenomenal perspective, I think, from the relators' perspective here. Our defense counsel is also here from D.C., Ralph Kasia. He's with Wiley Wren. Ralph is a former AUSA in D.C., and he is sort of one of the stalwarts of the white-collar defense bar. He does both civil and criminal defense work, focusing on false claims cases where he's represented corporations and their executives for years. Ralph has frequently run into the circumstance where the government either threatens to or does in fact seize money from clients in the pretrial setting. And then our government representative is the Deputy Civil Chief in the Eastern District of California, Colin Kennedy. Colin's been with DOJ for about 10 years, where she handles affirmative civil enforcement, specifically False Claims Act and Qui Tam cases for the U.S. Attorney's Office. And she has the unique experience of being one of few federal prosecutors, I think, that have actually dealt with the logistics of having or facilitating relators receiving their payment from funds that have been forfeited by the government.
How common is this? How often does this happen in the false claims arena where there may be this parallel civil asset forfeiture action?
Well, in a previous life as an assistant U.S. attorney and as the program manager for the forfeiture program here in Washington, we taught AUSAs follow up in every fraud case with a civil forfeiture component. And so it's something they're taught to do very early on in their evolution when they join the department and begin to learn about how the Department of Justice pursues fraud cases. And so you see it more and more over the last several years as it's really become ingrained in the culture of U.S. attorneys' offices to seize the money early and to preserve it for restitution for both government and individual or private victims. And so we've seen a major uptick over the last decade. Now the other side of that coin is we've got, of course, the right to due process. I mean, this is America, right? And so defendants have a Sixth Amendment right to fund and pay for their defense. And two of the major cases that are sort of at loggerheads that we're going to deal with are the Monsanto case, which is fairly well established, and that says, listen, if the government can show probable cause that a certain asset is in fact sufficiently connected to a criminal offense, they can hold that. And a defendant can't use that to pay for counsel. Now, we've got another case that's much more recent, Luis versus U.S., that says, well, that's fine, but the government can't hold and restrain assets that it can't connect to the offense. And where this sort of comes up is this notion of substitute assets or unconnected assets to the offense under investigation. And so we've got a rather robust playing field of issues to deal with here, both for relators who'd like to know, can I still recover my share if the assets are forfeited to the government, and for defense counsel and defendants who are saying, well, wait a minute, what is it that's there for me to retain to fund my defense to demonstrate that I'm not guilty of what I'm accused with?
So give me some of the advice that you're giving to your clients right now who might be facing a situation where they have assets that might be seized. What kind of advice are you giving to your clients?
This is really boils down to an accounting matter. Because this is going to be about ledgers and spreadsheets and transactions. The forfeiture law and the law that deals with what is it that the government actually can seize and restrain under a proceeds theory or an involved in property theory, money laundering theories of forfeiture actually can be quite confusing because of the evolution of the case law. And so it's not really so clear cut as just to say, well, this money came from pot A or this money came from pot B. And so it's a situation where you really have to bring more than just sort of legal acumen to the table. It's something that you're going to have to involve CPAs, forensic accountants, and other sorts of professionals and experts in to really sort of drive your point home and fill out your defense.
So Scott, tell us a little bit about you personally. When you're not practicing law, you're not with your family. What's your passion? What gets you up in the morning?
Well, you know, I'm from Mississippi, which you know, some folks who are watching the video probably could glean from my lack of an accent that you know, I'm from the South. So I enjoy outdoors things, hunting, fishing, sports, things like that I can do with the family, and so I just those types of things that you'd sort of guess that a guy from the South would be involved in.
Wonderful. Scott, thank you. We look forward to seeing each of you on February 27th and 28th here in Washington at the Qui Tam conference. You can find us at fedbar.org.